Judge Marla Yacht, move away from the bench.
I can hold this entire room.
Reporting has you agreeing to the sentencing range.
You will not stand in my courtroom and pretend an audio clip outranks a judge's order.
This operation had been in the works for nearly a year. Marlena Yost, a sitting county judge with 10 years on the bench, walked right into it. By the time that marked cash changed hands, the FBI already had everything they needed.
Currency followed the same attorney court.
Then charge me in your building, not mine, because this room still answers to me.
Her voice was on the tape. That was the problem. Not rumor, not implication, not a stranger's word against a sitting judge. Her own voice, negotiating a felony sentence for a dollar amount on a recording made 3 weeks earlier by a lawyer wearing a wire. The FBI had listened to it 22 times before knocking on her chamber door. By then, agents had already traced approximately $490,000 through 3 attorneys, 1 courier, and 2 cash-front businesses across Driscoll County, Kentucky. 21 defendants had bought their sentences from her over 3 years. Every other defendant she had ever sentenced now had a legitimate question about whether they had received the law or the market. Real talk. Have you ever sat in a courtroom and wondered whether the person on the bench was actually impartial? Sound off in the comments and tell me what happened. Subscribe now if you want to see more accountability content. This channel goes after the ones the mainstream ignores, every single week. Marlena Yost was born in 1968 in Whitesburg, Kentucky, a coal country seat in the eastern edge of the state, roughly 7 miles from the Virginia line. Her father, Randall Yost, was an assistant county attorney who ran unopposed for 2 terms and kept a law office above a hardware store on Main Street. Her mother, Frances, taught 8th grade civics at the local middle school for 31 years. The house Marlena grew up in sat at the end of a gravel road named for her grandfather, a former sheriff who had held office through most of the 1950s. Law and public office were the family trade before Marlena was old enough to read. She graduated valedictorian of Letcher County Central High in 1986, gave a commencement speech about the weight of the robe her neighbors had always trusted her family to wear, and left for Lexington that August. At the University of Kentucky, she double majored in political science and history, worked 20 hours a week at the law library reshelving hornbooks, and finished her undergraduate degree in 3.5 years. She entered UK's Rosenberg College of Law in the fall of 1989. Her class rank never fell below 7th. She served as an articles editor on the Kentucky Law Journal. Faculty evaluations described her as unusually composed under pressure, meticulous in her citation practice, and already carrying herself like a judge. The last comment came from a professor who had spent 14 years on the State Court of Appeals. She graduated in 1992 and took a clerkship with a federal district judge in Louisville, then joined the Commonwealth's Attorney's Office in Fayette County as an assistant prosecutor. Her starting salary was $38,200. Her first assignment was misdemeanor arraignments in the morning docket. Within 18 months, she had moved to the felony trial division. Within 4 years, she was second chair on murder cases. Colleagues remembered her as hard but fair, the one who actually read the presentence reports, and the only prosecutor in the office who could recite the sentencing statute from memory. She married Preston Yost, a real estate attorney in private practice, in 1995. They bought a 2-story brick home on a quiet block in Chevy Chase, Lexington, and had 2 daughters. Camille arrived in 1997 and Whitney in 2000. Preston coached both girls in youth soccer. Marlena served on the parish council at their church for 11 years and volunteered as a moot court judge at her law school alma mater every spring. Her professional evaluations from the Commonwealth's Attorney's Office consistently used the phrase candidate for the bench from 2001 onward. In 2014, the seat opened. Judge Halverson, a fixture on the Driscoll County trial bench for 23 years, announced his retirement in March. Marlena filed for the nonpartisan election in April. Her campaign literature emphasized 22 years of felony trial experience, her father's service as county attorney, and the phrase "the law without fear or favor" printed under her photograph. She raised $116,000, most of it from Fayette and Driscoll County attorneys, who had appeared opposite her in trial. She won the November election with 58% of the vote. She was sworn in on the first Monday in January 2015 in a small ceremony in the historic courtroom of the Driscoll County Judicial Center. Her father, then 81, held the Bible. Her mother wept. The photograph appeared on the front page of the Driscoll Herald-Leader the following Wednesday, under the headline, "Yost takes the bench her grandfather would have recognized." For the first 6 years, no one had a single word to say against her. She was known on the bench for reading every presentence report cover to cover. She ran a punctual docket. She issued written opinions on suppression motions when most trial judges in the state ruled from the bench. Defense lawyers who lost in front of her tended to lose respectfully. Prosecutors who lost tended to lose the same way. Her sentencing decisions clustered close to the middle of the statutory range in most categories. If a defendant went low, there was usually a stipulated reason on the record. If a defendant went high, there was almost always a prior offense that explained it. She was, by every visible measure, exactly what her campaign literature had promised. That was the reputation the money bought. Kentucky's felony sentencing structure gives trial judges a defined range for every offense class. A Class D felony, the lowest tier, covering many first-time drug offenses and low-value theft, carries a range of 1 to 5 years. A Class C felony carries 5 to 10. Class B, 10 to 20. Class A, 20 to 50, or life. Inside those ranges, the trial judge is the controlling voice. The Presentence Investigation Report, prepared by the Kentucky Division of Probation and Parole, recommends. The prosecutor argues. The defense argues. The judge decides. The practical difference between the low end and the high end of a Class C felony is 5 years of a human being's life. For a defendant weighing a plea offer, the single most important variable in the calculation is not the statute, not the prosecutor, not the strength of the evidence. It is the judge's known sentencing posture. A defense attorney who can accurately predict where a specific judge will land inside the range has an enormous negotiating advantage. A defense attorney who can influence where the judge will land has something far more valuable than that. Kentucky judges also hold discretion over suspended sentences and probation. For many Class D felonies and some Class C felonies, the statute permits the court to suspend all or part of a sentence and place the defendant on supervised probation, sometimes with drug treatment, sometimes with home incarceration, sometimes with nothing more than periodic reporting. A suspended sentence is not a lenient sentence. It is, functionally, a walk. The defendant serves no time in a state facility. The presentence report may recommend incarceration. The judge may override it. The record documents the reasons. The reasons, on paper, are almost always defensible. Driscoll County's felony docket, during Yost's tenure, ran approximately 600 cases a year. The overwhelming majority resolved by plea. Trials were rare. Sentencing hearings were routine, brief, and in most cases, unremarkable. The courthouse had one criminal division courtroom, one criminal division judge, and one clerk who tracked disposition data. Nobody in the building, not the elected prosecutor, not the public defender's office, not the probation division, was in the business of auditing the sentencing pattern of the sitting trial judge for statistical irregularities. There was no such audit anywhere in the Commonwealth of Kentucky. Judicial discretion, by design, resists that kind of measurement. The system trusts the judge, and the system had trusted Marlena Yost for 6 years without reason to look twice. The first payment arrived in the spring of 2021. The defendant was named Devlin Marchetti, a 29-year-old with 2 prior drug convictions and a new charge of first-degree trafficking in a controlled substance. That was a Class C felony carrying a range of 5 to 10 years, with the presentence report recommending 7. His attorney was Kellen Baird, a solo practitioner who had represented 4 defendants before Yost in the previous 12 months and had known her socially since her prosecutor days. Baird approached Marchetti's family with a proposition. He would need an additional retainer of $35,000 above his standard fee to pursue what he described as an aggressive mitigation strategy. The family produced the money in cash over 11 days. At sentencing, the prosecutor argued for the presentence recommendation of 7 years. Baird argued for the statutory minimum. Yost, after a careful 11-minute oral ruling that cited 3 appellate cases, imposed 5 years, suspended in full, with 5 years of supervised probation and mandatory outpatient treatment. Marchetti walked out of the courthouse that afternoon. Baird kept $15,000 of the additional retainer. $20,000 moved to Yost through a courier named Rusty Chatham, a former process server who had known Baird since high school. Chatham carried the cash in a nylon gym bag to a car wash on Route 421 called Cedar Fork Auto Detail, where the owner, a cousin of Chatham's by marriage, ran the currency through the business's daily deposits over the following 2 weeks. The money entered Yost's personal financial ecosystem as, ostensibly, proceeds from the sale of a small parcel of family land in Letcher County. Nothing happened for 11 months. Then it happened again. The second attorney was Delroy Prater, a criminal defense specialist with an office 2 blocks from the courthouse, and a client base drawn largely from methamphetamine and prescription fraud cases. The third was J.C. Hollifield, a younger lawyer who had clerked for Yost's predecessor and who had, colleagues later said, always seemed to know things before anyone else did. Between them, Baird, Prater, and Hollifield handled approximately 80% of the paying cases identified in the eventual indictment. All 3 used the same courier. 2 used Cedar Fork Auto Detail. The third used a small bourbon and tobacco shop off the state highway called Barrel Works Package Store, where the owner accepted a cut for laundering deposits through his daily cash intake. The pattern that formed inside the paying cases was not visible from any single decision. Yost never gave every drug defendant a suspended sentence. She never automatically hit the low end for every Class C felony. What she did, in the roughly 21 paying cases across 3 years, was locate a defensible legal justification for the specific outcome the payment purchased, write it into her ruling, and support it on the record with citation. A first-time offender's family stability, a cooperator's assistance to law enforcement, a mental health diagnosis, a drug treatment placement. The presentence report might recommend 7 years. Yost would find a documented basis for 3. The prosecutor might object. The record would show why the objection was overruled. Any single sentence, read in isolation, was defensible on appeal. The escalation was gradual and disciplined. In 2021, the arrangement produced approximately $92,000 in payments to Yost across 5 cases. In 2022, the number grew to $168,000 across 8 cases. In 2023, it reached $230,000 across 8 cases, with individual payments climbing as the reputation of the arrangement spread quietly through the county's defense bar. Yost's household reported no unusual expenditures. She did not buy a new car. She did not move houses. She did not purchase visible luxury goods. What she did do, and what would matter later when the forensic accountants started to work, was pay down the mortgage on the Chevy Chase house by $160,000 in cash equivalent principal reductions over 3 years, invest $98,000 in a certificate of deposit under her mother's name, and quietly acquire an 11-acre parcel of land in Letcher County adjacent to her father's original property. The parcel was recorded in Camille Yost's name, her elder daughter, a graduate student at the time, who had no meaningful income of her own. No one in the courthouse noticed a thing. No one checked. The prosecutors kept losing sentencing arguments at a rate that was statistically indistinguishable from the rate at which prosecutors lose sentencing arguments in front of any competent judge. The public defenders kept winning some and losing more, which is what public defenders always do. The clerk kept entering dispositions. The presentence reports kept being written and, in some cases, overridden with careful written reasoning. The system trusted the judge. The judge understood what the system trusted, and she operated exactly inside its blind spot. The break came from a case Yost had never touched. In late 2023, a federal task force in the Eastern District of Kentucky, working a methamphetamine distribution ring that ran product from Cincinnati into Eastern Kentucky, arrested a mid-level distributor named Vernon Marlowe. Marlowe was 34, had 2 prior state convictions, and was facing a federal indictment carrying a mandatory minimum of 10 years. His attorney negotiated a proffer session. Marlowe agreed to sit with FBI agents and Assistant United States Attorney Alana Whittemore and answer questions about the organization above him, the organization below him, and any adjacent criminal activity he had knowledge of. Marlowe was cooperative and detailed for the first 90 minutes. He named suppliers, transportation routes, and stash houses. Then, roughly 2 hours into the proffer, in a passage that transcript notes later described as unprompted volunteered material, Marlowe made a comment that stopped the room. He had, he said, a state trafficking conviction from 2022. Class C felony. He had been looking at 7 to 10 years. His lawyer, whom he named, had told him there was a way to get it done. The lawyer needed an extra $45,000 beyond the retainer. His family had come up with the money. He had received a suspended sentence and probation, walked out of the courthouse that afternoon, and been back on the street inside of 90 minutes. He described the sentencing judge by name. He described the courtroom. He described the ruling as reading to him, like she was reading it off a piece of paper somebody wrote for her. Special Agent Reed Coburn, seated in the corner of the interview room, wrote 3 lines in a notebook, closed the notebook, and after the proffer ended, walked directly to the AUSA's office and closed the door. Within 72 hours, a preliminary review of Yost's docket over the previous 3 years had identified 12 additional cases with similar profiles. Class C or Class D felonies, where the presentence report recommended incarceration, and the judge imposed suspended sentences on defensible but consistently narrow grounds. Within 2 weeks, the FBI's Public Corruption Unit out of the Louisville field office had opened a formal investigation under the case designation Corpub KY 4419. The investigation was, by design, invisible. No subpoenas were issued that would generate courthouse gossip. No interviews were conducted with courthouse staff. No search warrants were sought. What the FBI did for the next 4 months was watch. They watched the 3 attorneys. They watched the courier. They watched Cedar Fork Auto Detail. They watched Barrel Works Package Store. They pulled bank records under national security letters and traced the flow of currency backward from Yost's mortgage payments through her mother's certificate of deposit through the land purchase in Letcher County. They mapped the entire architecture of the payment system before anyone in Driscoll County had any idea a federal investigation existed. By March 2024, they knew enough to move. The undercover operation was authorized in April. The Bureau's plan was as clean as the architecture it was targeting. An FBI cooperating attorney, a former prosecutor from a neighboring district who had agreed to work the operation in exchange for consideration on an unrelated matter, was inserted into the network through Kellen Baird. The cover story was straightforward. The cooperator had a client, a fictional defendant named Roland Kessler, charged with a fictional Class C trafficking felony backed by Bureau-prepared documentation, including a fabricated indictment, a fabricated presentence report, a fabricated arrest record, and a fabricated set of case filings that would survive casual scrutiny inside the Driscoll County clerk system. The cooperator approached Baird in May and asked, in language calibrated over 3 weeks of preparation with FBI agents and DOJ prosecutors, whether the arrangement was available for a case like this. Baird understood the reference immediately. He arranged the meeting. Stories like this don't get the coverage they deserve. Judges who sell sentences do not usually end up on the national news. If you want to see the ones the mainstream skips, subscribe and hit the bell. We break down every detail of how these networks actually operate. The first meeting between Yost and the cooperating attorney took place in her chambers on the afternoon of June 11th, 2024, after the docket had cleared. The cooperator was wearing a recording device concealed inside a fountain pen, clipped to his suit jacket pocket. The audio was clean. Yost, in her own voice, spent 37 minutes discussing the fictional case. She asked about the defendant's family. She asked about the strength of the government's evidence. She asked about the presentence report's likely recommendation. Then, in a passage that would appear in the indictment verbatim, She said this: Yost. For a range like that, at that recommendation, we're looking at somewhere around 40. If the family can put together 40 by the end of the month, I can find the reasoning. I've done it before, with this pattern. The cooperator asked what she meant by 40. Yost. 40. Cash. Through the usual channel. The recording continued for another 14 minutes as she outlined the sentencing posture she would adopt, the specific written reasoning she would use, and the timing of the hearing to allow the payment to clear. She never used the words bribe, payment, or bribery. She did not have to. The specificity of what she agreed to left no interpretive room for any defense that might later attempt to reframe the conversation as innocent judicial discussion. The marked currency was delivered on June 28th. Rusty Chatham picked up the nylon gym bag from Kellen Baird's office on a Friday afternoon. The bag contained $40,000 in 20s and hundreds, each bill photographed and serialized by the Bureau. Chatham drove the bag to Cedar Fork Auto Detail. The cash business owner separated the currency into daily deposit portions. Over the following 11 days, the marked bills moved through the car wash's business account and into a personal account controlled by Yost's mother, from which the funds would ordinarily have been applied to the Chevy Chase mortgage. They never made it that far. On July 10th, 2024, at approximately 6:15 in the morning, a coordinated set of federal search warrants was executed simultaneously at the Yost residence in Lexington, her chambers at the Driscoll County Judicial Center, Kellen Baird's law office, Delroy Prater's law office, J.C. Hollifield's law office, Cedar Fork Auto Detail, Barrel Works Package Store, and Rusty Chatham's residence. Agents recovered marked currency at 3 separate locations, including 280 of the original serialized bills in a lockbox in the Yost family's basement. They recovered a handwritten ledger from Kellen Baird's office, which Baird had maintained for personal reference, documenting the case names, dollar amounts, and courier dates for 11 of his paying cases. They recovered text messages, encrypted app communications, and, from a legal pad drawer in Yost's chambers, a set of contemporaneous notes in her own handwriting, cross-referencing case numbers to figures that matched the payment amounts. Text messages recovered from Rusty Chatham's phone included exchanges that would appear at charging as evidence of intent. Chatham, April 4th, 2023. Kay says the package is ready when you are. Baird, April 4th, 2023. Tuesday works, same drop point. Chatham, August 19th, 2023. Big one this time, confirm before I move it. Baird, August 19th, 2023. Confirmed, full amount, she knows. The forensic accountants worked backward from the marked currency and identified approximately $490,000 in payments to Yost over the 3-year period. 21 cases were identified as belonging to the paying pattern. Each was documented with the corresponding attorney, the corresponding payment amount, the corresponding courier date, and the corresponding sentencing decision. The recording captured the exact moment Judge Marlena Yost's career ended. At 6:17 a.m. on July 10th, 2024, Special Agent Reed Coburn and 3 other federal agents approached the front door of the 2-story brick home in Chevy Chase, Lexington. Preston Yost, in a bathrobe, opened the door. Coburn identified himself, presented the search warrant, and asked for Judge Yost. She came down the staircase in a gray silk robe, her hair still uncombed, and stopped on the 3rd step from the bottom. Her expression, one agent later described, did not change at all. She had understood what was happening before she reached the landing. Coburn. Judge Yost, we have a warrant to search this residence. We also have an arrest warrant for you on federal charges. I need you to come with us. Yost. I want to see the warrant. Coburn. Yes, ma'am. Here it is. Yost read the warrant on the 3rd step of her own staircase for approximately 45 seconds. Her expression, according to the agents present, remained composed. She then looked up at Coburn and said, in a voice one agent described as sounding exactly the way she sounded on the bench, Yost. I'd like to call my attorney before we do anything further. Coburn. You can make that call after processing, ma'am. I need you to get dressed and come with us now. Yost, may I ask what the specific charges are? Coburn, bribery of a public official, honest services wire fraud, conspiracy, and obstruction of justice. Federal counts, state counts referred concurrently. Yost said nothing else in the house. She dressed. She walked out to the unmarked federal sedan under her own power. A neighbor across the street, retrieving a newspaper, watched from her porch. The photograph the neighbor took with her phone would appear on the front page of the Lexington Herald-Leader the following morning. Yost was seated in the back of the sedan, her posture upright, her hands folded in her lap. She looked, in the photograph, exactly the way she had looked in the campaign literature 10 years earlier. The daughter of the county attorney, the granddaughter of the sheriff, the woman who had promised the law without fear or favor. The caption underneath the photograph read, Yost, in custody. The indictment was returned on July 23, 2024, by a federal grand jury in the Eastern District of Kentucky. It ran to 89 pages. The lead